528, State of Texas versus Arthur Scarborough. Can I have parties announced for the record for the state?
Michael Villery off the state.
Matt Stolhansky from Mr. Scarborough.
And are you Mr. Scarborough? Showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it? Are you the same Arthur Scarborough who was placed on deferred adjudication in 2019, CR 8528, for the offense of aggravated assault on March 28, 2022 for a period of 10 years? Is that you?
Yes.
State?
Violated conviction number 13B on or about the 24th day of August 2022 in Bexar County, Texas. The defendant, Arthur Etoku Scarborough, defended there failed to comply with the instructions of the Bexar County Community Supervision and Corrections Department Offender Program, and that the defendant failed to comply with the instructions of Lone Star Offender Treatment Program, his court-ordered Offender Treatment Program, and that the defendant was suspended from offender treatment for failing to admit responsibility for his offense in violation of condition number 13.
How do you think to that? True or not true?
True. And the state would waive and obey the intervening allegation.
Did you understand by pleading true to violation of condition 13B, court could find it true, grant the motion, find you guilty, and sentence you to life in prison and up to $10,000 fine?
Yes, sir.
Knowing that, do you still wish to plead true to 13B?
Yes, sir.
Court will find 13B true. Is there an agreement?
There is not, Your Honor.
All right, state, what are you requesting?
So this is a case where I think Mr. Stolhansky would like to present first, potentially, because it really part of our argument is going to depend on the potentially new willingness to admit certain culpabilities. And so, from the state's perspective, if he's willing to take some responsibility, that might lend itself to him being continued on probation with some type of like ISF. But if he's not, then the issue becomes for us is what do we do with this person who is not willing to be rehabilitated? They cannot be in our community without being rehabilitated.
I don't believe ISS will accept him.
That was the original recommendation. So I think they would, based on that, but the court is much more knowledgeable on those aspects.
Well, I mean, we're all open to learning things. Probation, if you can look into that. And defense, do you have a witness to call?
Yes, Your Honor, I do. I would call Mr. Scarborough.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record. All right, you're going to need to speak up.
Arthur Scarborough.
All right, defense.
Hold on. Is this the microphone here? Was it better if I put it here?
No, just everyone just speak up.
That's great. Mr. Scarborough, you understand why you're here?
Yes.
Okay. And the polygraph, they said that you denied liability or culpability. Is that correct?
Yes.
So did you ever deny that this thing happened?
No.
Okay. And tell the court what your thinking was.
At the time, I didn't want to believe that it happened. But I accept 100% responsibility, not partial responsibility. I accept 100% responsibility.
And so it was about who instigated the start of this.
Right.
Because when you took your polygraph, you said that she was as much of an aggressor as you were. That's not true.
That's not true.
And that you were
I was the aggressor, and I accept responsibility for that.
And that was the reason that he was expelled from the program.
Right.
State, do you have any questions?
So I just want to make sure that I'm clear and I'm understanding is that you reported initially to your offender provider that this was unwanted and not provoked or initiated by you. Do you remember telling them? You did say that?
Yes.
And are you telling this court now that statement is not true?
That's not true.
Okay, that this was wanted and that it was provoked by you?
Right.
Okay.
I've had a lot of time to think it over, especially while I was incarcerated for 61 days, and then I'm on house arrest for the 35 days. And I realize that I am the one that's at fault.
Okay. Do you remember having a conversation with your center provider, Ms. Vicki Elliott, and her giving you that opportunity to say the truth?
Yes, and at that time, I didn't want to believe that that was the truth.
And isn't it true that when she confronted with you about this and letting you know that you'd be exited from the program and that you would potentially have an MTR, that you still at that point decided that you weren't willing to take responsibility?
I did take responsibility, and I told her at that time that I accept 100% responsibility. But I still stuck to the story that I wasn't 100% at fault as the aggressor. But I realized after thinking it over for so much time that I'm 100%.
Okay. But you also
I accept the responsibility, and I wish to continue the truth.
and you understand there's a distinction between, it's not really taking responsibility to say that a provoked this, right? That's not really taking responsibility. You understand that? So when you said initially you took responsibility, that's not really taking responsibility.
When I talked to the counselor after I felt the part,
I'm sorry? I can't hear you.
when I talked to the counselor after I failed the polygraph test, I did take 100% responsibility.
Okay.
But for her, that wasn't a good enough answer.
Okay. So you're still, you saying that it happened, but that provoked it and that it was
No.
unwanted is taking
No.
100% responsibility.
No, that's not.
Okay.
I accept 100% responsibility. The child did not.
I'll pass by this.
Any other questions?
Pardon?
Any other questions?
I just want the court to tell the court about your health issues that we're dealing with.
My health issues, I have a terminal illness called cystic fibrosis that affects my lungs, mainly my digestive system and sinuses. I have chronic sinusitis.
Which is why you're wearing the mask.
Yes, I can't be around. I'm real leery of germs. I have ulcerative colitis, and I have obstructive sleep apnea, where I have to be on CPAP. All of those things that I didn't get the proper medications and things like that when I was incarcerated. And I don't want to go through that again.
And other than that one violation, you're behind a little in the money because you didn't pay while you
While I
were.
was incarcerated. Yes.
But other than that, there are no new offenses.
No new offenses.
And that you are the transportation for your mother.
Yes.
And your mother goes to the doctor, hospital,
Yes.
at least once a week.
A couple times a month, to the pharmacy as well as once. I'm the primary caregiver, which I've not been able to do for the last 95 days since I was locked up in a house.
And she lives on your street
She lives 100 yards from me, but I can't go and see her
because of the monitor.
because of the monitor, house arrest. And I'm the one who takes care of her. My sister has had to take off work and suffer financial loss because of that.
Okay.
All right, anything else?
Just one further question, Judge.
Yes.
Did you have cystic fibrosis when you committed this offense?
Yes, I was born with cystic fibrosis.
Okay.
The genetic terminal illness.
I have no further questions, but I just wanted to make the board aware that Ms. Vicki Ellie is here if the board has any questions for her as far as probation is concerned.
All right, would you like to call Miss Elliott? Events?
No, ma'am.
Okay. All right. Any other witnesses from either side?
No, ma'am.
State, what are you requesting?
Judge, I'm going to request that this court revoke his supervision at this point. You've prosecuted cases, you have defended cases. I think this is a clear case where he still is. He's saying, well, I took 100% responsibility afterwards, but that's just not the case. That's why we're here. That's why he pled true, is that he didn't take responsibility. And that there is the inability at this point for the state to do anything other to ensure that our community is safe from him potentially reoffending. And that would be the place in a corrections department so that he can't have access to children. This is a case that, obviously the state recommended initially, but that was, the court's aware that we do that in certain circumstances due to victim cooperativeness cooperativeness and really times taking into consideration the further well-being of victims. I think he was given an opportunity. He continues to not take this seriously or make good efforts in progressing his treatment. And so we're going to ask the court to revoke his community supervision and sentence him.
All right, defense, what are you requesting?
And Your Honor, we're asking that you leave him on probation. He's done 60 days in jail. He's been on monitor for 30 house arrest for 30 days, 30 something days. That he completely admitted today in open court that he was the aggressor, was the child anyway. I'm not sure what the state was speaking of when he said he's not accepting responsibility. He's telling you that he did it, and he admits he did it, and it was his fault. And, he had time to think about it in jail, and that this is 100% responsible for this, and it's his fault. I would ask you to leave him on probation. He's committed no other offenses. He's been a pretty good, other than this one thing, pretty good probationer.
All right, is there anything else for me to decide?
Nothing further to say.
All right, the court is going to grant the motion, find you guilty, sentence you to 10 years in prison, give you credit for any time served, Chapter 62 registration, no contact with the complainants, showing you what's entitled trial court certification of defendant's rights to appeal. You do have a limited right to appeal, and that is as it relates to the allegation in the motion, not the fact that you were on probation. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Good luck to you. 24 CR 2985, State of Texas versus Daniel Balderas. Can I have parties that answer for the record for the state? Defense?
Elizabeth Settle for the defense.
Are you Daniel Balderas?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Balderas, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, sir.
Did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with unauthorized use of a vehicle? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Balderas, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $500 fine. State recommends deferred adjudication. This is the run concurrent with County Court Cause number 733375. There's to be restitution, if any, to Maybelline Cortez. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There be a TAP evaluation and 120 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Contest, ma'am.
State any evidence.
State offers state exhibit 1 and all evidence.
No objection.
All right, and state, have you spoken with the complainants?
Judge, we've made attempts to reach the complainants, but so far I don't think.
All right, thank you. You may be excused. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation and testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, we just ask that you follow the plea bargain.
All right, how old are you?
19, ma'am.
All right, why are you riding in stolen vehicles?
Just hanging around the wrong crowd, to be honest,
No.
ma'am.
You are the wrong crowd. That's what other people would say. The co-defendant or the other suspect who's with you, Sandoval, his family would tell me he's hanging around with the wrong crowd and that would be you. So what are you doing with your life?
To be honest, I'm just trying to finish school and get a job and just do
How
good.
are you just trying to finish school? What are you doing?
Well, right now I'm looking for like schools to be able to get my GED and my high school diploma.
You can find that anywhere on the computer. If you can drive around in a car that doesn't belong to you, I'm sure you can go on the computer. Do you have a phone?
Yes, ma'am.
A cell phone?
Yes, ma'am.
I'm sure there's Google or whatever on that cell phone. You can Google, there's places throughout San Antonio where you can get your GED.
Yes.
Why didn't you finish school?
And I was in juvenile, didn't get a chance to finish it.
All right, do you have any children?
No, ma'am.
Okay, that's a good thing. You need to get your life in order. You understand?
Yes,
Who do
ma'am.
you live with?
My mom.
All right. This is what the court will do. There is a $500 fine that will be probated. Court is going to sentence you to 2 years deferred adjudication. This is run concurrent with County Court Cause number 733375. There's to be 120 hours of community service restitution. That will be waived if you obtain your GED or if you're in some sort of trade school and you graduate. Do you understand?
Yes, ma'am. I did.
There's to be regular reporting by Zoom or in person. If you're drug tested today, what are the results going to be?
Clean
All right, when's the last time you used?
months, since like six months.
And using what?
Marijuana.
All right, there's going to be regular random UAs. And make sure he's tested for levels if he comes out positive. If he is positive, what we're going to do is there's going to be the UA hotline if he's positive. And he's going to stay on that UA hotline until he presents with a negative UA. And then we'll go back to regular random UAs. There's going to be proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. There is to be no contact with the following persons. Kevin, I don't know if this Kevin, in the police report, it's Keving. Ricardo, Richardo, Alvarez Sandoval. There's to be restitution and no contact with Maybelline, Mabeline, Ashley Cortez. And let him take the theft course. And there's to be field visits, one time per month, until he is employed or obtaining his GED. Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
I was just wondering about my GPS monitor. The hours, it's been kind of like interfering with me getting a job because I already had like 2 job interviews, but the hours that I got for my curfew, like my officer said he wasn't able to do nothing about it. So,
All right, we'll extend his curfew on GPS. So his curfew, he's allowed out of the house from 7 a.m. to 8 p.m. Monday through Fridays. And then Saturday and Sunday, he's to be at home unless he's employed or at school.
Judge, how long will he be keeping the monitor on?
Until further notice. We'll see how things go. How long you are on that monitor is 100% dependent upon you. Do you understand?
yes, ma'am.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing, you're young. Let me just tell you something. If you want things, go out, get a job so you can afford things. But at the end of the day, when all of us die, guess what? Your things cannot go with you. Although I've heard of people being buried with their car, which I don't know why you would do that because it's